Okay, hi everyone. Thank you for tuning in. And as we all know, today we'll be discussing the case of CTEB, the federal court decision. And this case touches on a fundamental right under the federal constitution, which is citizenship. And issues on citizenship is actually not a new issue. We have heard about the problems with statelessness, discriminatory nature of the laws, issues with Malaysian mothers giving birth to child overseas, where the father being a foreigner resulting in the child not being able to attain Malaysian citizenship automatically. But our focus today is on this federal court decision in the case of CTEB and another against Ketua Pengarah Pendaftaran Negara and two others. So the facts of this case is rather straightforward. In this case, a child was born illegitimate to a Malaysian biological father and a Filipino mother. Well, after 5 months after the child's birth, the parents actually legally registered their marriage in Malaysia under the Law Reform Marriage and Divorce Act. And this fact that the parents subsequently got married under Malaysian law legitimized the child's status. So the question is whether an illegitimate child born outside Malaysia to a Malaysian biological father and a Filipino mother is actually entitled to become a citizen by operation of law under our federal constitution. So in this decision, I understand that it's a split decision of 4-3. So let's start with Michael. Right. What did the majority decide in this case, and why? How did the court decide?
Okay. Hi everyone. Michael here. Good to be back after a long time. Since the last time we had this, I think was last year. Okay, so I think we only have the benefit of the press summary. So whatever I'll be saying will be based on that press summary. So basically, firstly, I think what the federal court prefaced was that based on the reading of Article 14(1)(b), that provides that that to obtain citizenship by operation of law, it must be determined at birth, okay, not after. So that was the starting point which the federal court started their discussion, right? So the majority actually is quite straightforward in the sense that they said, according to section 14(1)(b), which is qualified by part 2 of the second schedule, it says that although every person born outside the federation whose father is at the time of the birth is a citizen and either was born in the federation or is at the time of the birth in the service of the federation or the state will be entitled to citizenship. But section 17 of part 3 of the second schedule says that in the cases of illegitimate children, the term father is referred to as mother, meaning the child is not entitled to the citizenship following the father. So in this case, the federal court held that the child who was correctly given I think because in that case it says that the child was issued a passport and was presumed to be a citizen of Philippines, and the court said that that was the correct status of the child. But then the court also said the child may be qualified to be considered for citizenship by registration under Article 15 sub 2 of the Federal Constitution, which he has to apply to, or the child has to apply to the government to obtain citizenship. So basically, the court what the court has done is if the father is a Malaysian and the wife is non-Malaysian and they're not married, citizenship would follow the mother. Okay, meaning the child will not be Malaysian. All right, so that's if in effect what the decision of this court is.
All right, thanks, Michael. So what about the minority judgment in this case in you? Why was the outcome different from what the majority decided?
Hi, hello everyone. Thank you for tuning in. Thanks, Jack, and for moderating, and thank you, Michael, for explaining the decision of the majority, which I thought was quite a straightforward one, because they read the Constitution literally. And I think that's where it really differs from the minority judgment. In the case of a child born illegitimate whose father is a Malaysian citizen and a mother who is not a Malaysian citizen, the minority, with its leading judgment by the Chief Justice, found that in interpreting Article 14(1)(b) together with Section 1B of Part 2, Schedule 2 of the Federal Constitution, there is no need to rely on Section 17 of Part 3. Like Michael explained earlier, Section 17, it refers, it's a provision which provides for the interpretation of a person's father or his parents or one of his parents. When such person is illegitimate, such reference to a person's father, parent, or his parents shall be construed as a reference to the mother. So the Chief Justice found that in relation to Section 17, it only applies in a situation where the identity of the father is not known, and only the mother's identity could be relied on to determine the child's citizenship. And the Chief Justice relied on the minutes of the Working Party of the Constitution. And this is basically a document which sets out the intention, or it captures the reasoning behind why certain provisions of the Constitution is drafted in a certain manner. It's like a handset in a hall, sorry, not a hall, a Dewan Rakyat. So the minutes of the Working Party, it elaborated in its comments on Section 7.3, which later became Section 17 of Part 3. And these working minutes seem to suggest that the intention of the drafters in inserting Section 17 of Part 3 was to provide for a situation where a child born outside of the Federation and identity of the father was unknown, the mother being a citizen or later becoming a citizen is sufficient a reason to confer citizenship on that person so claiming. So it was not meant to impose an additional condition on Section 1B of Part 2, Schedule 2 of the Federal Constitution, which, like Michael said, every person born outside the Federation whose father is at the time of birth a citizen and was either born in the Federation or is at the time of birth in the service of the Federation or a state. So the Chief Justice also relied on the fact that Part 3 being a supplementary provision, which means that it is meant to supplement or it's meant to fill up any lacuna or gap in the law. And in this case, there was no lacuna because Section 1B of Part 2 of Schedule 2 of the Federal Constitution is already clear. And on top of that, the majority, again, led by the CJ, also decided that in the manner of interpreting these provisions of the Constitution, which the judiciary is currently doing, and which is done by the majority, it is discriminatory against the parents. It discriminates against an illegitimate child who has the right of blood to be a citizen, and it is also discriminatory against Muslim child because a Muslim child, unlike a non-Muslim child, is only considered legitimate if that child was born after 6 months from the marriage. So that in essence is the spirit, or it's a summary of what has been decided by the majority. The Chief Justice was joined by Justice Nalini and Justice Mary Lim. And for Justice Nalini, she wrote a separate judgment, but it was largely on the same reasoning as the Chief Justice. So, yeah, that's all.
Okay, thank you, Sinyu. So I guess it's actually a very difficult problem to decide because the crux of the case depended on the interpretation of the laws itself, and that's why there's this split decision. But can you tell us why is the citizenship of the child in this case decided based on the time when the child was born? Right, because in this case, the court actually looked at the time when the child was born to see that he's illegitimate in the first place, and that's why he should be following his mother's citizenship and not the father's.
Michael, you want to take that?
I think it's like what Sinyu mentioned just now. They read the constitution rather literally. That is why the factors they did not go into the intent of the provisions, but instead read it literally. That's why we are in such a state lah. So that if you see the reasoning behind the provisions, the intents of the provisions, like Sinyu laid out earlier, I think the outcome would have been different lah.
Yeah,
Okay.
I think what the majority has decided is that if the wordings of the constitution is clear, you don't need to rely on any extraneous sources. So if it can be decided based on the wordings alone, then whatever the effect is, that's not something the court has to decide, because the court must apply the law. So in that sense, why it was said that the child citizenship is decided at birth is because those words were contained in section 1B of Part 2 of the Schedule 2 of the Federal Constitution. Every person born outside the Federation whose father is at the time of birth. So they relied on whose father is at the time of birth a citizen. And they didn't go further into inquiring what exactly was the intention and the purpose behind this particular provision, as well as that in section 17. Had they done so, like what Michael said, the conclusion would have been different. I suppose in many ways the majority is not wrong in saying that, but when it comes to constitutional matters, where sometimes its application or its effect seems to result in absurdity, which I would say in this case results in a form of absurdity, because you have a situation where the child is not citizen, even though one of his parents is a Malaysian citizen. So, but simply by virtue of the child's legitimacy, or rather lack of it, which is something that the child cannot control at all, the child is stuck with the effect of the constitution. So I think in this case, there was an absurd result that has been created by how it was interpreted by the majority. And when the effect is absurd, I think it's entirely justified to look back at the historical documents, to look back at what we call the travaux, I can't pronounce it French, the preparation documents, yeah, to ask why is it meant to be applied this way? Why is it written in such a manner? Was this absurd result intended? If it wasn't intended, then is there some other way which we can interpret, which we can apply the provisions in the Constitution? And the minority found that, yeah, there was another way, and it's justified and it's supported by the historical documents, the preparation documents. So the intention of the drafters have never been to impose an additional requirement of a child being legitimate before the child can obtain citizenship or can inherit citizenship. I think inherit is a better word, because you look at the two principles of citizenship in this country, jus sanguinis and jus soli, those two have been met. So legitimacy is not part of jus soli, is not part of jus sanguinis. So that's why the seeming effect of what the majority has decided, it doesn't sit well with prevailing human rights standards, international principles, and certainly doesn't sit too well within other provisions of the Constitution as well, especially vis-a-vis Article 8, which provides for equality before the law.
All right, thanks. I think before we go on further, I think I should let the audience know that if you guys have any questions, you can just drop it at the comment section of our Facebook Live and we'll address it. So we have one question from our Facebook comment. Someone is asking, what is the state of the stateless child? I believe that in our case, this child, he's not stateless, like what Michael said, because he's presumed to be a citizen of Philippines. Right, Michael? Please correct me if I'm wrong. So he's asking, can Malaysia deport the child back to the country of the mother?
In this case, I think there was a presumption that the child was Filipino, so because the child had a passport, Filipino passport also.
All right. Okay. Another question: how can a child born out of a legally recognized marriage to a Malaysian man then get citizenship given the outcome of this case? I believe Michael also addressed Article 14 and Article 15, and Article 15 being the alternative for the child in this case.
Yeah, if the effect of the judgment, like I mentioned earlier, is that if you're not legitimate at the time of your birth, then you are not able to acquire citizenship unless your mother is Malaysian. So if your father is Malaysian and you're illegitimate and your mother is of another citizenship, what you have to do is to apply for citizenship by way of registration under Article 15 or 15A. But the problem with that is that it's not by operation of law. So there is a discretion on the part of the government whether or not to confer you citizenship. And that is, in practice, we know that that is very problematic because, number one, the government takes forever. It takes 3 or 4 years, purportedly, of background check. I don't know why background check needs to take so long. And even then, there's no guarantee that you're going to get it. So a lot of those applicants, which we have met in practice, they normally have their applications rejected. So you have to apply for a second time, and by the time you are 21, your application might not have been approved. So you have gone by quite a substantial amount of years where you do not have citizenship. And that is a big problem because the law and the federal constitution, it discriminates against those who do not have citizenship, against non-citizens. So if you look at Part 2 of our federal constitution, which provides for fundamental liberties, some fundamental liberties are only available to citizens. And the most glaring example is Article 5, where if you're not a citizen, you can be detained for up to 14 days. Whilst if you're a citizen, it's just 24 hours. And then, of course, you have Article 8, 2, where you can be discriminated. You have Article 10, where freedom of expression, speech, association, and freedom of speech and expression, association, and assembly, it's not available to you. So a lot of laws, as a result thereto, can be used against you, even though some laws might not be used against citizens. Of course, that's just the legal effect of it. There's also a stigma against those who are not citizens. You consider a migrant, party, everything else, and how the climate is in this current day and age is that there's a lot of this very bad stigma that's being created by the government against migrants, and of course the pandemic merely exacerbated it. So it's not a great situation if you're not a citizen in Malaysia and you have to live here.
Okay, let's see. All right, the next question. What's the effect of this case on future children who are in the same situation of the child in this case? That's the first part of the question. And the second part is, what are the important takeaways from this case? Yeah, either Michael or Sinu.
I'll go first. I think parents, they need to be very aware, or rather prospective parents, they need to be very aware of the discriminatory nature of our laws. And this is a very practical solution, and I don't want to play the moral purist card, but you should know that you ought to know that your effect, the effect of not getting married when it comes to your child's citizenship. I think that's something very important to bear in mind. Of course, a lot of this, sometimes it's planned, it's not planned, but that's just one very practical approach. Yeah, the law is bad. I agree entirely. We need to change it. I agree. We need to lobby more. We need to, the government need to act better. I agree. But at the same time, we got to be mindful that in spite of all these problems, do we want to subject the child to a whole host of discrimination or lack of rights by not taking the necessary steps before having a child? That's just my very practical solution. Of course, it's not, you might even argue it's not even a solution, in fact, it's just some very practical advice.
All right,
Michael?
Michael, do you want to share the important takeaways from this case?
I think, to put it very simply, it's for illegitimate children who are born out of wedlock, motherhood, so citizenship follows motherhood. So whoever is the whoever in that situation, right, the citizenship would follow the mother. So I think, and it's unfortunate for parents who are sort of who are Malaysians. So that's the problem with this decision now.
Okay. I guess we can address the last question before we sum up. What exactly needs to be amended in the federal constitution? So I guess just as you touched a bit about amending the federal constitution, would you like to elaborate 1 or 2 points on this?
Yes. I think an immediate solution to this problem is you only need a simple majority to amend Part 3 of Schedule 2, which is the supplementary provision of Part 2. Sorry, I got confused with the numbers. Too many numbers here. But that interpretation, which Section 17, which is really the source of the problem, that can be amended with simple majority. You actually don't need 2/3 in order to amend that, and that's provided under, I believe, Article 31 of the Federal Constitution. So once that provision is gone, the rest of the Constitution, as far as Schedule 2 is concerned, there is no reference to whether the child is legitimate or illegitimate. So it's only a problem where the legitimacy only is a problem created by Section 17. And I think in this day and age, there really should not be any distinction between a legitimate child or an illegitimate child. For me, that's a discrimination by descent. So that's a fast fix. Of course, there should be a more holistic fix. You need to look at other provisions which of Schedule 2, which you should change as well, because there's a reference to paragraph 1A refers to parents, either of them or both of them. Then paragraph B refers to father, C refers to father. So why not change everything to parents? What's the harm in doing that? Why is it only the father can confer citizenship? Or why can't the mother do that? So, it doesn't make sense, or rather it's no longer applicable, certain provisions which are currently there in the federal constitution, which perhaps made sense in the 1950s, because societies change. And in the majority judgment as well, there was a lot of discussion as to what the Constitution is. The Constitution is an evolving document. But the problem is the task of ensuring that the federal Constitution evolves in accordance with the times it is in, or the society which the federal Constitution is applicable to. That's not just something that should be left to the judges or the judiciary. Everyone has a stake in the federal Constitution. Parliament should take a proactive step to ensure that a lot of the outdated provisions in the federal Constitution be updated. The government needs to take the lead as well. So in many ways, you don't want a too interventionist judiciary when it comes to interpreting a constitution, because that too can be a double-edged sword. But when it comes to Parliament, what have they done in the past 50 years? We have seen minor updates here and there. The major one was back in 63. After that, you perhaps have one or two amendments which actually made the constitution worse. The emergency provisions and all that. But you don't really have a review of the existing provisions of the constitution to make it in line with the times. If everyone is criticizing it, I haven't heard anyone who's not in support of allowing illegitimate children to have citizenship. So if that is the case, why hasn't anything been done? Sorry, went on a bit of a rant there.
Okay. Actually, we got a question, like a new question when you were elaborating. It's on the Legitimacy Act being considered and read harmoniously with the federal constitution. I believe this is what the minority in this case actually did, right? Sinu? The subsequent
No,
marriage
not really. The Legitimacy Act, it was mentioned, but the way I read it, it wasn't used to determine what exactly Article 14, Section 1B of Part 2 of Schedule 2 meant, because it's clear enough through its own words what it meant. It meant father. So if that is its meaning, there is no need to refer to anything else. Section 17 also is not needed because it's already clear. Section 17, like what I mentioned earlier, it's only needed when the identity of the father is unknown. But that being said, I think I'm not sure if this was tested, but the fact that you have a Legitimacy Act which makes legitimate a child subsequently through subsequent marriage, or rather marriage after the child was born, you should be able to hold that against the government, because that is Parliament's expression that there should not be a discrimination against a child who is illegitimate. And legitimacy, like what the federal court says, it's a construct of law. So the government, in applying article, well, if it's not an Article 15 application, the government should nevertheless not discriminate against children who are illegitimate. Because ultimately, citizenship is something for the government to confer, you see. So why is it when it comes to illegitimate child, despite the Legitimacy Act, the government could go ahead and discriminate against illegitimate children? So that's something that could be held against the government. In fact, I would go so far to say that there is a legitimate expectation that illegitimate children, when applying for citizenship, even though they did not have citizenship in the beginning, should have a legitimate expectation that they would be given citizenship. The mode of application, of course, is secondary, whether you go under Article 15 or 15A or other provisions.
All right. That's another question. All right. So if the child in this case had automatically acquired Philippine citizenship, how can this child acquire additional Malaysian citizenship?
I think this one, the federal court said that because he had the passport, Philippines passport, because I don't have the full grounds, but then based on the press summary, it says the child, there was a presumption that the child had had Philippine nationality because of the passport he held. But I think the court said that him holding a passport, the child holding a passport, does not disqualify him from applying or having consideration whether he's actually whether he should be considered be given citizenship under Article 15. So yeah, so it did not disqualify him from being considered whether he was whether he could be a citizen or not, because you are only yeah. So that was the situation based on the summary I'm reading here.
I think in this case, the argument is that the child should be a Malaysian citizen by operation of law. So it should be something that is automatically given. Okay? So that's our starting point. If the child is by operation of law a citizen, except for one E situation, but just ignore that for a moment. In the context of a 1B situation, which is in this case, whether the child is a citizen of another country, that is an irrelevant consideration. That should not even be taken into account. What should I know where this the questioner, person asking this question, is coming from. In Malaysia, we have prohibition against dual citizenship. Agree. But here, the child is operation by citizen by operation of law. If that child also has Philippine citizenship, that doesn't stop the operation of law, because it's not a requirement when you consider a 1B situation. What will happen is that the government realizes that, okay, now you are a Malaysian citizen and you are also a Philippines citizen, assuming that the child is a Philippine citizen, yeah, then there are certain provisions in the constitution that is applicable in stripping a person of their citizenship. But before the person can be stripped of their citizenship, Malaysian citizenship, they need to first be a Malaysian citizen, which is the argument in the very first place. This child needs to be a Malaysian citizen first. And in deciding whether a child is a Malaysian citizen, like I mentioned earlier, whether that child is another citizen elsewhere is not a consideration under the federal constitution.
All right. Thanks, Sinyu and Michael. So I guess that's the end. There's no more comments from our audience. So before we wrap up, sorry, before we end this, can we do a quick wrap up? Like, Michael, can you go give us the takeaways from the majority decision and Sinyu a few pointers from the minority decision? Just a summary.
No, I think I already mentioned it earlier. Basically, the takeaway is if you are if the father is Malaysian, wife is not Malaysian, they are not married, child that is born out of wedlock, the citizenship would follow the mother. That's it.
All right, Sinyu.
I think there are other ways to continue this fight. Interpreting the constitution saying that it's a right, I think that journey has, for the time being, come to an end. But that doesn't exonerate the government from its obligations, not just under the constitution, but under the Convention of the Rights of the Child, under the CDAW as well. I think there's a CDAW challenge that's going on. So I think there are other ways to challenge the discriminatory nature of the federal constitution. Simply because it's discriminatory in nature, it doesn't mean that the government should apply it that way. You see, the government has a great deal of discretion in a lot of things. So other modes of challenge can be launched. I can think of a few, but I think for the purposes of this talk, we don't need to go into that. It can get quite technical.
Okay. All right. So I guess that's the end of today's talk. Thank you, Michael and Sinyu, for spending your afternoon with us today. And to our audience, we will be back with another topic next week. So please stay tuned on our Facebook page and we'll update soon. All right. Thank you, everyone. Have a great day ahead.
Thanks, everyone.
Bye.
Bye.
Bye.